Yeah, I don't think probation is for you. I'm going to grant the motion. I'm going to find you guilty, revoke. This will run concurrent with 2025 CR 014998. The court will sentence you to 20 months in the state jail facility, give you credit for any time served. And I'll ask for the therapeutic community.
Vincent Munoz walked into Judge Stephanie Boyd's courtroom with a baby on the way, a job offer waiting, and a grandmother who had set aside $300 for his drug tests. His attorney had every argument laid out. What his attorney did not have was a probation record that looked any different from the one Judge Boyd was about to read out loud. Barely $38 paid toward his fees. 9 drug tests missed. No approved residence maintained. 1 class finished in jail after getting arrested again. I don't think probation is for you. What had Munoz said moments before that made that the only sentence Judge Boyd could give?
State versus Vincent Munoz. Could I have parties announced for the record for the state?
David A. Garcia, attorney for Vincent Munoz, judge.
And are you Mr. Munoz?
Yes, ma'am.
Counsel, in that cause number, have you received all discovery? Did you review it with your client?
I have and we have.
Court will find that the state is in compliance with discovery. Mr. Munoz, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Judge, proceeding on this lesser.
Any
No
objection?
objection.
Did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, the state is proceeding on the lesser included offense of criminal trespass as a Class B misdemeanor. The range of punishment is up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand?
Yes, sir.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, and the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, and he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a U.S. citizen, by entering this plea, you may be deported, denied naturalization, and reentry?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of criminal trespass. Punishment is to be assessed at 114 days in the Bexar County Jail. There's an $800 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sure.
Counsel, there be any such motions?
No, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
We've reviewed states one and all attachments, Your Honor. We have no objections.
All right. Mr. Munoz, did you review the document entitled Waiver and Stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, regarding the misdemeanor that he's pled to, we're just asking that you go along with the plea bargain and that it run concurrent with whatever ends up on happening on his SDR.
All right, this is what the court will do. Court will follow your agreement. The court will find you guilty of the lesser included offense of criminal trespass. Court will sentence you to 114 days in the Bear County Jail, give you credit for any time served. There's an $800 fine, time and money to run concurrently. So with regards to sentencing,
No, Judge.
and I'm so sorry, and this will run concurrently. All right, 2024 CR 1361.
Yes.
All right, on that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
We're moving on to cause number 2024 CR 2024 CR 1361. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Vincent Munoz, who was placed on deferred adjudication in 2024 CR 1361 for the offense of abandoning a child criminal negligence on April 9, 2024 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition order and verification Texas, the defendant Vincent Munoz did and there failed to report to the supervision officer as directed for the month of June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And that could be under.
No objections.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility
Yes.
and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There's not the that you needs motion and revoke his community supervision and sentence him to 2 years in the state jail facility.
All right, in defense, what are you requesting?
Judge, we went open so that my client would have an opportunity, one, to be reinstated, and if in the alternative, to see if you could be a little bit more lenient than the state. He faces 2 years state jail. Clearly, he made a lot of mistakes. Probation's recommending revocation.
Mhm.
State's recommending revocation. He just pled to a burglary that was reduced down to a criminal mischief. He made a lot of bad choices. He was close to finishing one of his classes, and then the burglary arrest occurred. Doesn't excuse what happened. He made a bad mistake to go someplace with who's now the mother of his child? Kimberly. Mother of his child to be. She's due in 4 months?
She's due in June.
In June.
5 months.
5 months. He
What
should,
did you do when that criminal trespass occurred?
No, we found out she was pregnant when she was incarcerated.
Okay.
she got arrested with him
Ah.
at that instance. She was, our understanding was the main aggressor at the door, but the state reduced her case to a criminal mischief, and they did so with my client. He understands he made that mistake. He should have never been there. They went there to get the clothing for Kimberly's children, not his child, correct? But nonetheless, it was a bad mistake to go. He understands that. That's why he took this plea. He understands he had been making a lot of mistakes on his probation, but while he's been sitting in jail, Judge, he's tried to turn his life around. You saw the certificate of completion for the child class, the fact that he's been going to meetings. He's really been trying to change things for himself, even though he understands he made a mistake and it's a grievous mistake. He's throwing himself on the mercy of the court, hoping, one, you reinstate him. He's got a job waiting for him. He's got this baby coming in 5 months. And if not, he understands, but he's hoping you give him a more lenient sentence to 6 months in state jail or a year, so that he can do his time and get back to his job and help raise his child and move on in his life.
So what has he done on probation? Has he done anything?
I did,
Want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All
Yes, Your Honor.
right, you can lower your hand, state your name for the record.
Vincent Munoz.
All right, what have you done on probation?
I completed my first class with the driver safety course. I was right before catching this charge. I was one class away from finishing my parenting class. Then after that, I was going to start my AA. I was showing up to my meetings and everything, but I didn't end up showing to my drug testing because money was tight, but also I didn't have a reliable transportation. But my sister has an extra car that she paid off and got her new car, so she told me that hopefully willingly that she has another car for me so I can have reliable transportation to show up to my meetings, drug testing, my job and classes or anything that I need to do to be responsible for myself.
All right, any questions, state?
Or guest registration.
No problem.
Okay, Mr. Munoz, so when you were placed on probation, you provided the probation office with an address of 15800 Chaseville Boulevard. And then it was apartment 310 Fed. Do you recall that?
Yes.
Okay, whose apartment was that?
That was my ex-stepfather's.
Okay. And so one condition that you had in your probation, I guess it was amended later on, was that you were supposed to reside with your mother at 2503 Jackson Keller Road. Do you recall that?
Yes.
Okay, and so at the time that you were arrested for this charge, that you just pled to, the,
Criminal trespass.
you were not residing with your mom, correct?
Yes, ma'am. It's because they ended up splitting up.
Who?
My mom and my ex-stepdad.
Okay, so if I'm understanding correctly, that address at Chaseville Boulevard, so your mom and your stepdad were living together there, is that correct?
No, okay, so Boulevard, that was
Your stepdad's address.
no, the stepdad address was 2503 Jackson Keller and Chase Boulevard. I was staying with my partner's friend. She helped us roommate there, but I had ended up telling my probation officers because I had nowhere to go. That was my last option. Because I was throughout this time, I was back and forth through hotels and motels.
Okay, and so you were not residing with your mom, you were residing with Kimberly and then the friend that was helping you all.
Yes, ma'am.
Is that fair to say?
Yes, ma'am.
Okay, and then regarding your urinalysis, you were instructed to provide samples multiple times. If we're looking here. 9 times, you recall that?
Yes, ma'am.
Okay, and you didn't show up to provide you a 9 times.
Yeah, it was like I didn't really have too much reliable transportation, and it was just where I was staying at. My mom and people, it just didn't match their time schedules, what they were working, and I was trying my best, and every money that I did had, it was either helping out on rent or going on.
Okay, so help me understand this correctly, because you're saying that you have reliable transportation to go provide your analysis, correct? However, on the day that you were arrested for criminal trespass, you and Kimberly were in possession of a Dodge Durango, correct?
Yes.
And you all drove over to Dionisa's address, correct? So you have reliable transportation to go commit other crimes, but not to comply with your probation. Is that correct?
Yes, but I had just asked my sister if I could pick up her stuff. That was that extra car that she was that I was speaking of.
But she couldn't provide you help to comply with probation?
It was she had just got a new car about the beginning of September. So at the time when I did ask her, she was like, she didn't really want to let me use it, but she was just like, I just needed to get his clothes.
And then you stated that you completed the aggressive driving course, is that correct?
Yes, ma'am.
And probation was provided with a copy of that.
Yes, ma'am.
Okay, but you were also ordered to do your sober support meetings and parenting class, and the parenting class is something that you completed while you were in custody after being arrested, is that correct?
Yes, ma'am.
Okay. And then the one time that you did show up to UA in July of 2025, you were positive for marijuana, correct? And so you're here asking this court to be lenient on you, is that correct?
Yep.
But you have not provided any evidence to this court that 1, you deserve leniency, or 2, that you ever intended to comply with probation. You agree with me, right?
Yes, ma'am.
Okay. You pass the witness.
Any further questions?
Just a few, Judge. Vincent, you sort of glommed over the fact that you didn't show up to these UA tests because of transportation, correct? Was financial, and the financial aspect also a reason you didn't show up?
Yes.
Explain that to the judge.
A lot of money that I had saved up was going towards hotels, and I didn't really have nowhere to go, so that was mainly where my money was going at, and I didn't really have a car, so I would always use Uber to get food or something like that.
And you're not trying to tell the judge that you have an excuse for everything, correct?
No, I take full accountability for my.
So
for
you
my-
understand you did very poorly on this probation,
Yes.
but you're trying to explain why. It was, a lot of it was financial. And so you would show up to me with your probation officer, they would tell you to show up for a urinalysis test. And you told them you didn't have the money, correct?
Yes,
Because it costs every time you show up to give a urine test.
yes,
And so that's, and you pled true to not showing up because you didn't, right?
yes,
So even though you messed up on your probation, you were trying, correct?
yes,
And you almost finished that parenting class through probation, didn't you?
yes, I was one class away.
Okay, and then you got arrested because of another bad decision, right?
Yes, sir.
But while in jail, you did complete the parenting class.
Yes, sir, and then I started my AA classes as well.
Okay. If the judge grants you this opportunity to stay on probation, can you promise her, in spite of financial reasons, you'll make every meeting, you'll show up and you'll be clean?
I promise, and I do stand on that, as well as as I told her, I have reliable transportation. I talked to my grandma here a lot too. She put about 300 aside for me for my drug test. Kimberly as well, she has a few checks that she had saved up while being in here. She told me as well, she could help me with my restitution fees. And when I get my job, I can end up finish paying it off and then just do my AA classes. That's the only class that I have left.
No further questions, Judge.
All right, any objection to the court asking some questions, or State, do you have any questions?
I don't have any other.
No objections, Judge.
Since 2024, when you were placed on this probation, have you ever been employed?
I was working under the table most of the time with painting. And then I ended up, when I got arrested in October, and then when I got out, it was hard for me to find a job, but then I ended up finding a job and I was working about 3-4 months. They let me go. They were letting a lot of people go, but I was working under as a temp for Pacific Seafood. And then from there, I was working with my grandmother. She does events downtown, so I would work every weekend about selling food, setting up the booths, doing that. But while being in here, my mom has a job, and she ended up talking to her supervisors and her team lead, and they said that they have a spot waiting.
All right. And then did you tell probation that you would no longer be able to reside at the listed location?
Yes.
And that was ordered by another judge.
Yes.
When did you tell them you would not be residing at that location?
When I went to one of my probation meetings, I told her that my ex-stepdad and my mom, they ended up splitting up, kicked us out. Cause he has a new partner. And then I ended up going with my grandma's house, and then Kimberly ended up getting pregnant about 2-3 months while I was there.
All right, why do you say, I don't like when people use the term ended up getting pregnant. Were
Well,
you
no,
not a part of that?
No, yeah, I was, my fault.
So I mean, everybody knows, I'm assuming, how old are you?
Me, I'm 27.
All right, people know how babies are made. So you all
We both,
decide or to have a child.
she ended up being pregnant at that time, and my grandma didn't really, because of me getting locked up last year, with the situation due with her, they didn't really get along too much. So when she had ended up finding that out, she told me I had to leave. So I was staying with her at 6818 Centennial. I was there for about 2-3 months. Her and her mom ended up getting into it because she had a miscarriage. Then from there, that's when we were staying at hotels and we were just trying to find somewhere to go. And then I asked my grandma if I could stay there again. My uncle ended up moving in. He was just like, I don't want nobody living here because this is gonna be my house pretty soon. And I had nowhere to really go. And then while she found her friend, we stayed at Chase Boulevard. She was letting us stay there. And then right about the ending of September, my sister told me that she ended up getting an apartment. She got another car. She was like, if you do end up not staying there, y'all can come move in with me. And then all this ended up happening.
This is what I don't understand, and maybe you can help me understand it. Why is it that people, they don't have a place to stay? they don't have a stable employment, and they decide they're going to bring a child in the world and they can't even support themselves. And everything that you've told me, and I listened to your answers to the questions, everything that you've told me, you're relying on somebody else. Kimberly has money that she's been saving up since she's been in custody. Somebody else has money, your grandmother, they've been saving up money. And if neither one of them give you that money, we're going to be right back here.
Well, I have that job waiting for me, so I'm willing to work with that. My mom told me they paid from 17, 18 an hour, and I'd be working 3 days a week, so I'd save up all my checks and just pay what I need to pay off myself, take care of my responsibilities.
Any objection to the court reviewing the court summary?
No, Judge.
Any objection? Have you read the court summary?
Yes, Your Honor.
All right, after reading the court summary, probation is basically saying you were never compliant. They said that there was a previous motion to revoke, and this was with a different judge. They say following a motion to revoke filed on October 31st, 2024 for a new offensive assault, his conditions were amended on January 9th to require weekly reporting indefinitely and residency with his mother. It says, despite these directives, the probationer refused to reside with his mother, citing conflicts, and instead stayed temporarily in a hotel before moving in with his grandmother, failing to provide proof of residence. He has remained unemployed, completed only an aggressive driving course on May 20th, 2025, and otherwise made no progress or required parenting or other classes. He has paid only $38 towards his fees, leaving a delinquency of $1,412. And see, I understand when people can't pay money, but from 2024 to only have paid $38 towards your fees, that's sort of not really trying. And they say his reporting has been inconsistent with frequent failures to appear and intermittent walk-ins, and field visits were often unsuccessful due to his absence. A manager hearing on August 22nd, 2025 documented his continued noncompliance and failure to pay fees, during which he was encouraged to obtain employment. Despite these interventions, he remains noncompliant. Yeah, I don't think probation is for you. I'm going to grant the motion. I'm going to find you guilty, revoke. This will run concurrent with 2025 CR 014998. The court will sentence you to 20 months in the state jail facility, give you credit for any time served. And I'll ask for the therapeutic community. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, you have a limited right to appeal. The right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And I want you to know your attorney did do a great job, and I did listen to everything and internalize everything. But sometimes, you're just not doing well on probation, and there's nothing I can do. Okay.
Yes, ma'am.
All right. Good luck to you. Okay.
Thank you.
All right. Are there applications in these cases?
Sorry, Your Honor.
Court is calling 2025 CR 008396 and 2025 CR 014167, State versus Melissa Renee Paez. Can I have parties announced for the record?
Trey Mauer for defendant.
All right. And are you Ms. Paez?
Yes.
Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. In each cause number, Ms. Paez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And did you sign it? In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictments as presented in cause number ending in 96?
No, Your Honor, state moves to waive the enhancement allegation as well as count 2 and proceed solely on count 1.
Any objection?
No objections.
And are you proceeding on the indictment as presented in 6-7?
No, Your Honor, state also moves to waive the enhancement allegation in that clause.
Any objection?
No objections.
All right, and each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
And cause number in 9-6, you're charged with fraudulent possession or use of credit card or debit card, 10 to 50 items as a second-degree felony, range of punishment. I'm sorry, you're only proceeding on one count, correct?
Correct.
Okay, it's just the way it's printed out. We're good though. All right, the range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, sir.
If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. In the cause number ending in 6-7, you're charged with false statement or to obtain property or credit, $30,000 to $150,000 as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call him the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, sir.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Paez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, or reentry. Did you understand?
Yes, sir.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, the state is waiving the enhancement. And in cause number ending in in the cause number ending in 9-6, the state is proceeding on count 1. And in each of the cause numbers, the state is asking that your punishment be assessed at 10 years in the prison. There's a $1,200 fine. State is opposed to your application. They're asking that the causes run concurrently. They're taking in consideration 2025 CR 014168, 2025 CR 015020, and 2025 CR 015019. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? And each cause number, did you review the waiver of appeal paragraph? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
There are not, Your Honor.
And the cause number ending in 6-7, outside the agreement, there's to be no contact with Mission Mitsubishi at 9800 San Pedro, and there's to be no contact. Did you understand those were recommendations from the state, and the court does not have to follow that recommendation? Then in cause number 2025 CR 008396 to count 1, how do you plead?
Guilty.
And in cause number 2025 CR 014167, how do you plead?
Guilty.
State, in each of those cause numbers, do you have any evidence to support the plea?
Yes, Your Honor. State offers States Exhibit 1 and all attachments in both causes.
No objections.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, the state is opposed to your application. If you would like a PSI and a TAP evaluation, it'll be 8 to 12 weeks. If you would like it brought back sooner, I will listen to whatever witnesses or evidence that's submitted to me and make a decision.
Your Honor, after speaking with my client, we have a request if the court would consider signing the dismissals on the 3 cases that were taken into consideration in light of her plea of guilty and plea onto these 2 cases. If those 3 cases are closed out, and if the court would additionally consider reducing her bond slightly on the 2 that she has pled on, so she could take those full 8 to 12 weeks, organize her witnesses and people that she would like to be here on her behalf, and make sure that she has everything lined up for whatever the court does decide at that point. I believe that's what we are requesting, Your Honor, if the court would consider dismissing those 3 and possibly just slightly reducing the bonds on the 2 that she's pled on so she can organize everything and take the full time for the PSI.
All right, so with regards to bond reductions, you'll have to file a motion and then I'll hear it so that the state can be prepared.
Okay.
And if the state is waiving notice, just whenever you all get together, the court will do that. Now, with regards to the dismissals, any objections to the court signing the dismissals now or?
Object to it because that is something that ensures or will be dealt with at the resolution depending on what this court does.
And maybe I should have discussed this with you beforehand. If I may say, Your Honor, I've understood previously that if someone enters a plea and then does not return, that that plea can be, the court can say we're not going to accept the plea and that the full range is open. I believe that on its own will be sufficient to guarantee that she'll be here, and she'll accept whatever the court decides at that point.
All right, so this is what I can tell you all. This is new to me. With regards to the court signing the dismissals, the signing of dismissals to the court appears to be a part of your plea bargain agreement. And until the plea bargain agreement is accepted by the court, which it hasn't been accepted, right? The only thing that I'm doing is memorializing for the record that this is your plea bargain agreement. I have not accepted it yet. However, again, it's novel to me. If somebody brings me some case law that says that the court can make a decision with its own discretion to dismiss cases if a plea bargain agreement has been entered to but not accepted by the court, I'll consider it. But my understanding of the law is that unless the state says they're in agreement to these cases being dismissed now, they're really not to be dismissed now because your plea bargain agreement, I haven't even accepted it yet and entered a sentence. I've just accepted the contract that you want to enter into. Do you understand? All right. So, but again, if somebody brings me case law that says something differently, I'll review it. I never said I know everything.
We take a quick step back just so I can discuss with my client very briefly, Your Honor.
Sure. And then let me know if you all want the 12 weeks or not, 8 to 12 weeks or not.
Thank you, Judge.
Sure. All right, Norma. The attorney hasn't come back, but I know he said that he did not want the PSI on Mr. Smith. When do you want that brought back?
He said he's on his way back.
Ah, okay. And usually this is what I discovered. When we have a docket that is not as full, we still end up being here for a long time. But I like to make sure that I hear everything. And this is what I tell people about judges. Well, about me. I don't claim to know everything. I don't know every law under the sun. But if somebody brings me some law that says, Judge, you're incorrect, I'll listen to it and change it. Or if it's something that's novel, like that is novel, that's the first time that's been brought. But if he brings me case law and says, oh, no, Judge, it's within your discretion, then I'll hear it. Yes.
Your Honor, my client has decided to do not the full PSI, will come back sooner rather than later.
All right, so let's go. We're back on the record. If you'll come forward. All right, so are you asking that the PSI be waived? All right. And then with regards to TAP evaluation, are you asking that that be waived as well?
Is it gonna be the same wait time, Your Honor?
Vashon, how long is TAP, just for a TAP evaluation? TAP evaluation is 4 weeks.
We'll do the TAP evaluation, Your Honor.
All right, so there is a request for a TAP evaluation. It's in both cause numbers. It's 2025 CR 014167 and 2025 CR 008396. All right, Ms. Ferguson, what date? Yes, and Ms. Abrams, if they can expedite that and maybe get it to us sooner than 4 weeks, we'll try.
I can do February 25th. Oh, I'm sorry, the 26th, Judge.
February 26th. And if for some reason, if they're able to do it sooner, they'll let your attorney know.
Yeah.
All right, you're welcome. Is there anything else?
Nothing
All
conventional.
right, with that, we'll close the record.
Thank you, Your Honor.